In litigation, parties employ legal advisors that present cases to judges. The judges listen to the evidence and apply the law to their understanding of the facts. This is not an easy task. It takes a great deal of time and a lot of expertise to ensure that facts are properly placed before the court, and that a judge, when he or she takes a decision, does so on a proper understanding of the law. It's a time-consuming and a costly process, especially when parties move from one court to the next on appeals and cross-appeals in order to ultimately have their dispute resolved. In mediation, the mediator does not take a decision. The mediator leaves it to the parties to take the decision. What the mediator does is he uses considerable expertise, experience, and understanding in order to create an environment for the parties that will make it possible for them to find a solution to the problem. He encourages the parties to generate options for the solution of the dispute based on their interests and not so much on their rights. And by exploring these interests with the parties, the mediator is able to direct them into a situation where they find solutions that are win-win solutions, that is, solutions that they both find acceptable. It takes a fraction of the time and it costs a fraction of the money. The biggest difference between mediation and litigation is that in mediation, the parties themselves look for a solution that is based on their interests. That is, what is it that they really want out of the conflict? What is the solution to this conflict based on going forward what is in their best interest, and always in their joint best interest? In the case of litigation, a judge takes a decision based on rights, based on the facts measured against the law. The judge has no interest and cannot, in fact, even explore the real interests of the parties. He or she is obliged to take a decision based on the law. And in litigation, there is always only one winner and there is always one loser. In mediation, on the contrary, because one is seeking an interest-based solution, the solution that the parties themselves agree upon is always one that both of them find acceptable. In other words, a win-win solution, invariably based on interests that a judge simply never explores.